Miners and nobody can, and beep boop, we are ready. So welcome to the video lecture for chapter 16, lesson 3. It's going to be our last one for the semester, so get the tissues. This is getting close to the end of our time together. Womp, womp, womp. Topic for today is wrapping up the other end of trial rights, which are the rights that citizens have at trial and one of the rights that citizens have when they are being detained, the right to habeas corpus, the right to have a court review to make sure that their detention is lawful. I want to talk a little bit about a place that the textbook kind of skated around, but did not touch this area specifically. Our textbook did go into disproportionate sentencing for African Americans in the United States, but another important place within the justice system to understand the impacts of race is the promise of jury by peers. One of the things that our Constitution promises is that you have a right to a trial by jury of your peers in a criminal case. Well, what is a jury of your peers? For somebody who is a member of a specific racial group, well, then they might have a vested interest in having members of that racial group on the jury. Men might have an interest in having men on the jury. Women, an interest in having women on the jury. If you all appear in front of a jury made up entirely of baby boomers, they're going to view you as a Gen Z ne'er-do-well who might never learn, and they might be more inclined to look down upon you. Whereas if it's a group of your peers, they may be more likely to empathize with you. So one of our rights is a right to a trial by jury of peers, but what does that mean, and to whom, what does classify as your peers is an interesting constitutional question. In 1986, that was the time that the court had the largest case related to, or the landmark case really, related to this question of, for racial minorities, what constitutes a peer when it is jury selection time? Or, to put it a more precise way, to what extent is a Black defendant entitled to having other Black people on the jury? The ruling that the court came to in the 1986 Batson case is that you do not inherently have a right to have a jury made up to definitely have members of the same race, the same gender, the same religious group, etc., the same age group. But if you can suggest that people were, and if you can come up with a reasonable, plausible demonstration of a suggestion that people were excluded from that jury because they were a part of that group, that is a violation of your right to due process. That's a violation of your right to jury of your peers. In that, the court came up with a multi-pronged test, which effectively comes up with, again, it doesn't necessarily mean the composition of the jury needs to be exactly like the composition of society or exactly like the composition of the defendant in the case, but that if the defendant can show either in a general sense that, hey, wait a second, Georgia discriminates against Latinos on juries, or Georgia only brings in male jurors, or if they can show in their case specifically that, wait a second, that the jurors were being dismissed because they were of this race. Jurors were being dismissed because they were of this religious group, and that was unfair to me. If they have a plausible case to be made there, there's a good chance that they can have their convictions overturned and be open to a new trial. A couple examples of this. In 1994, we had this expanded to not just be race, but to include gender as well. It was JB versus Alabama. It was a custody case, but in this custody case, the one side was the woman's side in this custody case was eliminating all jurors and saying we won't accept all of these jurors, and was trying to create an all-female jury. The male in this civil case said, wait a second, this is clearly an attempt to build a biased jury against me, and it was ruled that, yes, he was not being entitled to a trial by a jury of his peers. That's a civil case rather than a criminal case, so it's a little bit different, but it shows, again, that jury by your peers can mean more than just the fact that there is a jury there, but that jury is constituted of people, or not is constituted of people who are like you, but hasn't been systematically built to disqualify people who are like you. This is one that continues to be controversial, and I pulled one recent case about it, but as I was looking this morning, I was looking at 4 other death row cases throughout the American South right now that are in some form of limbo because the person, usually because it was a Black male defendant who was convicted, and there is evidence to suggest that the prosecution, when making jury selection, was trying to prevent Black people from serving on that jury because they were afraid that Black people would be more sympathetic to a Black defendant. The one I listed here is Foster versus Chapman, because that was one that was particularly precedent setting and one of the earliest ones of this current wave of cases about it. It's also one that was especially egregious, as the prosecution's notes included things like circling the race of the jurors when they were taking notes on jurors, and marking ones with the letter B next to them if they happened to be Black, and included one note that said, Church of Christ, Black Church, no, 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 capital no. Our long, complicated history with racism continues even up through chapter 16. We've got a few more chapters left for that. Last thing I want to talk about is just picking up where, since chapter 16 will be our last chapter, picking up where our chapter 16 left off, which is on habeas corpus rights, and one's right to see whether or not their detention is lawful. The place where habeas corpus rights have been most controversial in recent years, I mean, after all, in history, it is going back to the Civil War and Lincoln's detention of Southern sympathizers without specific charge or without an immediate trial. But the Constitution says you can suspend habeas corpus rights during a time of insurrection or rebellion, and the Civil War counts as one of those. Where habeas corpus rights have become controversial in modern day is in detaining enemy combatants, detaining people who have fought against the United States, sometimes directly against the United States in fighting against their military, or sometimes in the aiding and abetting of terrorist organizations. In particular with the U.S. detention facility at Guantanamo Bay, the major detention facility that's used for people who are either enemy combatants or suspected of terror plots. Well, the question is, to what extent is somebody who has conspired against the United States entitled to the same legal protection as others? We have a series of cases that govern that, and I'm surprised that this textbook doesn't go over this series of cases, because they are important and pivotal to the question of what habeas corpus looks like. They all, not surprisingly then, stem from the years after the September 11th terrorist attacks, and beginning with some of the wars in Afghanistan and Iraq, when there was wide-scale detention of people who had taken up arms against the United States. The 2004 case of Rasool versus Bush dealt with a British citizen, somebody who had British citizenship, but was involved in fighting against the United States in, I believe it was either Iraq or Afghanistan. I believe it was Afghanistan. But a British citizen who had fought against the United States and was being detained by the United States. Is this person entitled to habeas corpus? Can they go to a U.S. court and argue whether or not their detention is legal? The Supreme Court looked at it, and they see the same 14th Amendment that we looked at earlier in this unit. The 14th Amendment does not say that there is equal protection under the laws just for citizens. The 14th Amendment says that there is equal protection under the laws for all people who are subject to U.S. law. If you're being detained by the U.S., you are subject to U.S. law because that is the law that you are being punished under, and therefore terror suspects or foreign nationals or enemies of the United States who are being held by the United States, even they are allowed to go to a court system and see whether or not their detention is legal. Now, the court system, when it's terror suspects and enemies against the United States. In the case of Razul, and in fact, in the case of, I believe, all defendants involved here, the court system have said, yes, your detention is legal. You're still allowed to ask and have that reviewed by the courts, but the detention of these individuals was ruled to be legal, just that they are also entitled to challenge and make sure that it is a legal detention. Similarly, in the 2004 case of Hamdi versus Rumsfeld, it was a same kind of topic, but it was slightly different circumstances because Hamdi was an American citizen who was captured as an enemy combatant. Well, still entitled to the full rights of citizenship, still entitled to due process, can still be detained, but is entitled to a legal process. It was then in 2006 that Congress started to rewrite what that legal process was. And Congress started to rewrite the law about how it is that suspected terrorists would be treated, and started to say, oh no, they don't go through the regular court system. They go through a special court system that we are setting up for terror suspects. In 2008, the U.S. Supreme Court invalidated the military tribunals that were being set up for terror suspects because this was viewed as a way to try to circumvent habeas corpus rights. And that was a case of a Bosnian national. So again, it's not habeas corpus rights, not just for Americans, but for anyone who is subject to U.S. law when one is being detained and awaiting trial, or when one is being detained post-trial, when one is being detained for a crime. Habeas corpus rights are one's ability to challenge whether or not that detention is lawful. Everyone has them, but that doesn't necessarily mean that the court's going to agree with you. That'll wrap up our Chapter 16 Lesson 3 lecture. That wraps up our lectures for Chapter 16. In just a little bit, I will stop the recording and we'll take any questions. But take care of yourselves and each other if you're watching this on video.